I'm Ilana Любін. I'm a partner in the New York office of Kroll and Mooring, and my colleague Preetha Chakrabarty will be presenting this presentation with me, and she will actually be kicking it off. She focuses in intellectual property and frequently makes presentations to designers of various companies regarding the design's do's and don'ts. I will let Preetha take it from here.
Thank you, Ilana. Hi, everyone. Very looking forward to this presentation. And just before we get started, just to make clear, any opinions that Ilana or I share during this presentation are our own opinions. They do not belong to our law firm or to any of our clients. And also this presentation does not constitute, is not legal advice. It is meant for educational purposes only. So with that, we'll kick it off. So as you can see on this beginning slide, I ask, what do all these photos have in common? So I won't tell you yet, but you will find out as we go along that all these different pictures highlight different things you need to keep aware of if you are designing or if you're a fashion retailer, making things, selling things into the US. So we are going to go through low risk designing, myths of what's out there, what people think are true and may not be true, some examples of different things to do and not do, and some tips to take away. The different types of intellectual property. There are a few different types when it comes to fashion. So you have design patents, which we'll go over briefly, trademarks and trade dress, which we'll go over in a little bit more length, and copyrights. As we go through each of these sections, we'll pause and take one or two questions if there are any questions, and then we'll save most of the questions for the end of the presentation. So design patents. Design patents cover the design of what something looks like. So right here, you can see this design patent covers a dress. It's a dress that perhaps to you looks like any other dress. But what this company has done is gone out and sought design patent protection for this dress. And what that means is they own, because they own this patent, they own the exclusive right to make that dress for a certain period of time. Design patents in the United States, if they were procured, if they were received after 2015, design patents are eligible for protection for 15 years. So that means for 15 years, this person, they don't have to make the dress, but they can prevent others from making the dress. And so we'll talk about what that means as we go along. Here's another example of a design patent. It's for a little child, it's for a baby, right? It has a soccer ball pattern on it. Again, somebody has a design patent for this. That means no one else can make it unless they get this person's permission. So how do you stay out of trouble when it comes to design patents? They're not as common as trademarks and copyrights in the fashion world, but they are common nonetheless. So you need to make sure when you're looking at a design patent, somebody else's patent, that it's an ordinary observer. What that means is somebody walking by on the street, if they looked at your design and they looked at the design patent, that the pictures I just showed you, that they would think that they're different. If they think that, then the person who has the patent might come after you, might say, hey, wait a minute, you're not allowed to do that. And in the United States, patents are enforced often in court, in federal court, and that can be very expensive. It can be a very expensive undertaking. And this is particularly true because to get a patent in the United States is very expensive. It takes a lot of time and it takes a lot of money. So if somebody has a design patent and you are infringing that patent, you're making something that looks too similar, they will likely want to enforce their patent, and often they will do that in federal court. Which can be a very expensive and timely undertaking. So here are some examples of design patent lawsuits that have happened in the past. So this is a picture from a design patent of leggings, right? You may be familiar with a design like this. Looks like sort of a common pair of exercise leggings, perhaps. This company was making the leggings that you see on the screen. Maybe to your eyes, they look a little bit different. You can look at the bottom of the legs and see that they don't have the black leggings don't have as many stripes as the one on the left. But anyways, the person who owns this design patent brought a lawsuit against the makers of this design, saying that to the ordinary observer, they look too similar and they shouldn't be allowed to make these leggings without permission. Here's another example, going back to the dress example I was showing you. This is an example of a patent for a dress. Again, may look like a simple dress that you've seen before. In this case, it's somewhat a convertible dress. You can change the fabric to make it look a little bit different depending on how you want to wear it. Excuse me. And so this company on the right side, the web pages you see, they started selling this dress. And as you can see, it's also convertible, right? You can wear the top of the dress in different ways. Again, the person who owns the patent brought a lawsuit against them. You don't own the patent, we own the patent. If you want to make this dress, you need to pay us money, basically. So again, this is an example of how design patents can be enforced. And actually, before we move on to trademarks, I'll pause really quickly if there are any quick questions about design patents. Otherwise, we can come back to them at the end. I know we were told that questions would be told to us if anybody had questions. Okay, well, I will move on then. Oh, is there a question?
Comment.
Oh, comment. All right, moving on then. So moving on to trademarks. What is a trademark? A trademark is a brand, a logo, a symbol, anything that marks your trade, anything that tells you, oh, this is from this company, this brand, so forth. There's also something called trade dress, similar idea, but the shape of something. And we'll look at some examples in a second, but just from this image that you see on your screen, that perfume bottle that you may see, that's an example of trade dress. You know, a lot of perfume companies in particular have very distinctive shapes to their perfume bottles. So as soon as you see it, you know it belongs to a Chanel, for example, right? A certain company. So that's an example of trade dress. One of the key things to remember is that trademarks in the United States and in most parts of the world, in fact, last forever. So as long as a company is using a trademark, using it in commerce, and they have to be using it, but as long as they are using it, trademark protection lasts forever. So for example, Nike shoes. Nike shoes have that famous swoosh, right? As long as Nike is using that mark on their shoes, on their clothing, Nike owns that and no one else can use it as long as Nike continues to use it. But that's just one example. There are millions of examples, gazillions of examples of trademarks around the world. And a lot of these are American, but I'm sure you may recognize many of them as brands that you are familiar with, or images that you've seen and you know belong to a company, right? So this is the world of trademarks. So you can see an image right away and know, oh, that's the McDonald's trademark, that's the Visa trademark, the BMW trademark, the Google trademark, and so forth. So there are, when you think about trademarks, and if you as a brand, as a designer are thinking of coming up with a trademark for your company, for certain parts of your brand, how do you think about them? What's a good trademark? What's a strong trademark? What's not? So in the United States, we think about trademarks on a spectrum. And what that means is, so looking at this slide, you can see that certain words and certain images are easier to trademark and certain others are harder to trademark. We'll start with the easier to trademark. Generally speaking, the more unique, the more weird perhaps a trademark is, the easier it is to trademark. So example here is Adidas, right? That company, that word doesn't mean anything other than having something to, other than now we associate it with the brand, right? The clothing brand, the athletic brand Adidas. But other than that, that word doesn't mean anything else in English. So the trademark office considers it fanciful, and that's a very strong trademark. A little less strong, but still strong nonetheless, Starbucks. Starbucks is everywhere, and Starbucks is, again, doesn't mean anything particular. Sure, the word star, bucks, those are words that mean something, but when you put them together and when you associate them with coffee, that doesn't, there's no connection there, right? So in that case, the trademark office considers it an arbitrary trademark, meaning that it's random, it's arbitrary how Starbucks has anything to do with coffee. So again, that's a pretty strong trademark. Now, if you go to the other side of the spectrum, you see that you have suggestive trademarks. Chicken of the Sea is what is a brand for tuna fish in the United States. And that is suggestive, right? Because a meat from the sea is tuna. It suggests the idea. So again, not as strong a trademark. Oat nut brand cereal, it describes exactly what the cereal contains. So that's a descriptive mark, not that strong. And then finally, you have generic marks. And in this case, aspirin, it's a medicine, is become a generic word for that medicine. That company actually a long, long time ago used to have trademark protection, but they didn't protect their trademark and everyone just started using the word aspirin interchangeably. So, excuse me. So after that, the trademark office decided anyone can use aspirin because it's now generic. The same thing goes for words like escalator, thermos, and other words you can look up to see what generic marks are in the United States, but there are a lot of words that you will use in the English language on a daily basis that used to be trademarks, but are no longer trademarks and are therefore considered generic and anyone can use them. But trademarks aren't limited to words and symbols. Shapes also qualify as trademarks. So these three different shapes, you may recognize some, you may not recognize all of them though. These images are taken directly from the US Trademark Office website. So these are images from actual US trademark registration. And therefore, these items you see here. So that first one on top is for a mouthwash bottle, for a scope mouthwash. The one at the bottom left is for Chanel No. 5, as we were just talking about a few minutes ago. Again, the iconic, famous Chanel No. 5 perfume bottle. Chanel is very aggressive about making sure not only no other perfume company uses that bottle, but no one can use that shape of a bottle, even on a t-shirt or on a poster or on a handbag. Chanel is very aggressive about making sure they protect this trademark. And finally, on the right side, I'm sure you recognize the Coca-Cola bottle. The Coca-Cola company has protected the trademark, the shape of their bottle, of their Coke bottle for very, very long time. And again, if you were to try to use this shape, even on a t-shirt, even on a handbag, Coca-Cola would likely object and make you stop. Some other interesting trademarks are color trademarks. This is an example of the Tiffany blue, Tiffany, famous jewelry company. And if you are familiar with them, you know, as soon as you walk into a Tiffany store, you see this color everywhere. If you buy anything from them, their boxes and bags, everything is in this distinctive blue color. And they have been able to protect this. So again, this is a color you need to be careful of. If you're designing jewelry, certainly, but even if you're designing apparel, this is a color we would recommend you avoid because Tiffany is very protective of this very specific bluish green color. Another fun color trademark to talk about is this red sole from Christian Louboutin's shoes. So those of you familiar with shoes, especially fancy shoes, may be familiar with this. So the image on the left is an image from Christian Louboutin's trademark registration. They have for the red sole. And as you can see on the right, that's an image of their shoe with the red sole. And this was actually quite controversial about 10 years back in the United States. There was a big lawsuit back and forth between Christian Louboutin and Yves Saint Laurent. There was a lawsuit because Yves Saint Laurent said, no, that's not fair. Who can own a color? Who can have a color on the bottom of a shoe, right? It seems a little weird when you're thinking about trademarks. You know, the color on the bottom of a shoe seems so different from the Nike logo, for example, or even for the Chanel bottle, even as a different example, right? But the court in the United States, the highest court that decided this case, said no, Louboutin can have this trademark. They are allowed to have this trademark of the red sole on the shoe, and they just made one condition. They said that Louboutin has to always use the sole on a contrasting top. So that means, as you see in this picture, the shoe is black and the bottom is red. So it always has to be different. So, and in that case, Yves Saint Laurent, who had brought this lawsuit, they had a red shoe with the red sole, and the court said that was okay. That did not infringe Louboutin's trademark. So something to keep in mind if you're in the footwear industry, certainly be very careful of using any red on the bottom of shoes because, again, Louboutin is very protective of these of this trademark and often pursues many shoe designers who try to use red soles. Again, these are some odd examples that you might not think have trademark protection, but do in the United States at least. So you see here two different guitars. I'm not a guitar expert. So when I look at these guitars, they don't look anything, special to me from, not that different to me. But if you zoom in and you look at the top of the guitar, which is called the headstock of the guitar, they're differently shaped, right? One is slanted, the other is not slanted, it's more symmetrical. It's very distinctive, and musicians, people in the industry, people who know guitars well, can see this and know right away that, oh, that's a Fender guitar or a Gibson guitar. So these companies protect very heavily too these trademarks. So the thing to remember about that, it's not, this trademark isn't just about guitars, the physical guitars. If you want to use a picture of a guitar on your shirt, or you're creating a handbag that has all different musical instruments on it, including guitars, be very careful about what your guitar looks like. Be very careful that it doesn't look like the top of the guitar doesn't look like either of these, because again, the reason we're sharing this example is that these companies very often come and try to stop people from using images of their guitar, even if it's, again, on a shirt or on a handbag. Key trademarks that the United States offer protection for. So if any of you have been to Washington State in the United States, to Seattle, this is a famous building in Seattle. And it too has trademark protection. It's the Space Needle building. And this is an example of a company many years ago who tried to use the Space Needle in an advertisement. And as you can see, it was kind of a funny advertisement. It was advertising food, actually, onion rings, I think. So you can see that around the Space Needle. But what was interesting is the Space Needle, the folks who own the trademark, they came after that company and said, you're not allowed to use our picture of the Space Needle unless you have our permission. Another example of a similar trademark is this building from New York City, where Ilana and I are both based. This is a picture of the Flatiron Building, a very iconic, famous building in downtown Manhattan. And this image too, this specific image also has trademark protection. And what that means is, again, you can't use this picture or this image on a t-shirt, on a handbag, whatever it is, without permission from the owners of the trademark. This is an interesting one that's being decided right now at the US Trademark and Patent and Trademark Office. So we don't know exactly how it'll come out, but this is a Valentino shoe. And you can see the studs, the metal studs on the shoe, right, all along the shoe. So Valentino is trying to get trademark protection for this. They're trying to say, this is our trademark. If you look at a shoe with these studs, you know it's a Valentino shoe. Now, so they've applied for a trademark. The trademark office has responded saying, no, that's not really a trademark. No one really knows that that's a Valentino shoe just because of those studs. But they're going back and forth. It's still undecided where this will fall out, but for those of you who are shoe designers out there, something to keep in mind that even if they don't get protection in front of the trademark office in the United States, you can bet that Valentino will continue to be very protective over at least this design that they often put on shoes. Other things that have trademark protection that you might not think of, many common phrases in the United States have trademark protection. So these are some examples. Could show you incredible things. This sick beat. Some of these words are from songs. Some of these words are from companies who have used these as taglines. The Super Bowl, which is a big sporting event in the U.S. In the early years. It's a football game that's like a championship football game. People aren't allowed to use the word Super Bowl without permission from the National Football League in the United States. And then these are just some other words that might seem common, like the word frisbee seems very common, but there's a company that owns the use of that word and you can't use it without their permission. So how do you stay out of trouble with trademarks? I know I just showed you a lot of worst case scenarios and we'll look at some more in a second, but the main thing to remember is you start infringing a trademark as soon as someone thinks that there's confusion. And in the legal term in the US is likelihood of confusion. So if someone sees your perfume bottle and maybe it's a square, but maybe it has a top that looks like the Chanel bottle, and someone looks at it quickly and is confused and thinks, oh, that's a Chanel perfume too. That must be the new Chanel No. 5 or something like that. If they're confused like that, that can be grounds for trademark infringement. And whoever owns the trademark can come after you. And again, as I mentioned before, with similarly with trademarks, if people have spent a lot of money on their trademarks, they will be more aggressive. So the famous companies that you can think of that we've talked about, like a Nike, Chanel, Disney, they are very protective of their trademarks. They've spent so much money over the years protecting the brand, protecting the trademark, so they will be very aggressive. So you want to be careful if you start putting out a brand, putting out images, that you are not running into any of those companies' trademarks. And the smaller companies too, of course, but this is just to say that the bigger companies are very aggressive, and no matter where you are in the world, really, they will find you. So some quick examples to run through. So on the left-hand side, again, these are examples from actual lawsuits. On the left-hand side, excuse me, you see.
We have a question from Sia Didenko. Why is that hot? Maybe for the previous slide.
What was the question?
Why is that hot?
So that's hot is from Paris Hilton, somewhat of a celebrity back in the 1990s and 2000s more so. That was a phrase she used a lot on a TV show, but also in connection with items she sold. And she was able to get trademark protection for that phrase. And we'll take some more questions at the end of this trademark section too. Left-hand side, you see Gucci's items and Gucci's signature trademark of those 3 stripes. I'm sure a lot of you are familiar with that. On the right-hand side, you see Forever 21 using similar stripes. It's not identical, but similar enough. And actually, if you look here, this is the whole range of clothes that Forever 21 put out, these stripes on different types of items. Sure enough, Gucci brought a lawsuit and Forever 21 had to stop using these stripes. Again, to the ordinary person, it might look like just red and blue stripes, fine. But to fashion designers, to those who know, to those who are careful about buying their clothes and know design, this was clearly a ripoff of what Gucci was doing and Gucci trying to promote. Another example goes back to Adidas, as we were talking about before. So these are, again, images from a real lawsuit. And as those of you who are familiar with Adidas know that their stripes, their 3 stripes are very famous, right? They protect them around the world, making sure no one else uses the 3 stripes, not only on sneakers, but on clothing as well. And we'll look at that in a second. So you may look at these 2 sneakers and say, why is one infringing and not the other? They look so similar, right? They have 4 stripes, not even 3. What's going on here? So we'll take a look in a second. And again, they're not just on shoes. Adidas, these are trademarks that Adidas has for clothing. They put their stripes on all sorts of clothing, as you can see here. And these different images at the bottom of the slide are images from, again, lawsuits where other companies tried to use stripes, mostly black or white stripes on clothing, and all of them were told to stop by Adidas because they said that they were infringing their trademarks. So I know this can, especially when it comes to stripes, it can be frustrating to fashion designers because you're thinking, well, what am I ever going to do? So we have some recommendations. Don't ever use 3 parallel stripes. If you're going to use stripes, use many more or many less. Also try to avoid, as you can see on this slide, 2 stripes or 4 stripes, because what Adidas has successfully argued is that if you use 2 stripes or 4 stripes, if you sort of look a little differently, you can see 3 stripes on each of the in between the stripes or right around the stripes. We always recommend staying away from white and black because those are the signature colors for Adidas. Use different colors, use different widths of stripes if you're going to use stripes on apparel. Another quick thing to look at, especially in the United States, very, very popular. This may not look like much. This image is from the trademark office, but this is the trademark for Levi's. And that little red square on the Levi's jeans, that little red triangle, rectangle on the side pocket of Levi's jeans, Levi's protects a lot. They've owned the trademark since the 1930s, and they are very aggressive about making sure that no one else making pants uses that little trademark. And it doesn't just have to be red. These are Levi's pants that have the little white trademark, the white flag as well. And again, Levi's is very aggressive about protecting this brand, this trademark. Levi's is also aggressive about protecting pocket stitching. So these are different pocket stitching designs that Levi's owns. So this is the back of jeans. I'm sure you've seen many jeans, right, with different stitching on the back. But hopefully, if you've seen stitching that looks like this, it belongs to Levi's. Here are some examples of Levi's signature clothing with that trademark. Again, Levi's has gone to great lengths to protect this very specific type of stitching. So this is, again, an example from their trademark registration. And these are some examples of companies that have had to stop what they're doing. So you can see on the top one, that red square. It's not even a rectangle, but it's red and it's a little flag next to the pocket. Not a good idea. Similarly, the image on the bottom has a little stitching on the bottom that looks similar to what Levi's has protected. Again, not a good idea to do anything close to that because will come after you. So what do you do with denim, right? Similarly, that can be hard because these look like such basic items. Stay away from rectangular shaped tags on the seam of the pockets, right? Even if it's red, any color, we recommend staying away. Certainly staying away from anything red. And even if it's on a t-shirt or on a different type of clothing, a little red flag will catch Levi's eyes, and it often does. And we say clear pocket stitching designs before use. So if you are a designer who makes these types of designs, make sure that you are talking to your team or you are investigating the databases in the United States to make sure Levi's or other denim companies don't have trademark protection for a specific type of stitching, because that is something that the trademark office allows protection for. And now, before we move on to copyrights, does anybody have any questions about what we just talked about? Okay, well, I'll keep going. So finally, copyright. So this is probably one of the biggest concerns and biggest things designers think about. Copyright protects original patterns and prints, unique color arrangements, novel new combinations of items, and fashion designs. Parts of fashion designs are protectable. Most often it's the patterns that you see. And there was a recent Supreme Court case in the United States that addressed this, and we'll get to that towards the end of this section. So before we move on, there are some common myths, especially in the design community, in the fashion design community, that people hold that are not true. So we want to make sure that everyone's clear that these are not true. Often people hear that if you change 50% of a design or 35% of a design, whatever it is, and sometimes people learn this in design school, they think, oh, I can use that picture, right? If I take a picture, change it 50%, I can use mine now. That's not true. That has no basis in the law, in US law. Another commonly held myth is that if something has copyright protection or even trademark protection, it will always have these symbols. The copyright symbol or the trademark registration symbol or just the trademark symbol. That's also not true. It's recommended that people who have protection for their designs use these markings, but they don't have to. And just because you don't see it doesn't mean somebody doesn't own the rights to that image or design. Also, just because you pay for something doesn't mean you can use it in any way you want, right? There are lots of websites where you can go and download a picture for money. You pay money with a credit card, they give you the picture, and then with the picture, there's a whole bunch of fine print, right? A document that tells you what you just purchased. Always look at that document and make sure that you know what you have purchased. Sometimes these documents will say, you can use this picture only 25 times for non-commercial purposes. And if it says that, that means you can't even use it on an item that you want to sell, right? So just because you paid for something doesn't mean you can always use it any way you want to. So just make sure to read the fine print. Let's say you find an image and you say, oh, this was made by my best friend, Anastasia. And you put that on there, and that's how you're using that picture on a t-shirt, let's say. If you haven't received permission from Anastasia to use that image, you are not allowed to use that image. Just because you tell somebody or tell the world that this belongs to someone else doesn't mean you can use it. You still need that person's permission. And finally, there's this concept of fair use in the United States, which makes it seem like that you can use copyright protection as long as you're using it fairly. But what fairly means is, as you can imagine, in the law, not up for debate. It's actually very, 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 very limited to political speech or parody. And it's something that journalists will use, for example, so that they can use certain images and names and trademarks and so forth and copyrights. But for the regular person, fair use is rarely a defense. So just make sure when you hear that phrase, it means something very, very narrow under US law. You also often hear that, oh, something's so vintage or retro or old school, these different ways of describing designs for people to think that they're so old, you can use them. Again, not the case, especially under US law. For something to be old enough for you to be able to use it, it has to be very old.